All right, I think we're live. Hi, this is Curt Verone,
And Brad Pinsky.
and we are here for another edition of Fire Law Roundup for July 8th of 2024. Brad, go ahead.
I am back from vacation, great mood, but for a minor hurricane in the Caribbean. So not so minor, honestly, it was for us. But okay, so today we have a lot of long, lengthy cases, which, as Curt and I always do for you, we will summarize. But I wanted to throw a curveball before we get into this. I want to throw out a, hey, this may be coming. People may have overlooked the importance of two U.S. Supreme Court cases that were handed down. And I want to, if we could, take a minute and discuss one of the U.S. Supreme Court cases because it's going to have a huge impact in my world for my clients. We think it's going to change all of New York State, a lot of New York State administrative law. So but it's going to do that nationwide. So let me explain very quickly. There was a case where the Securities and Exchange Commission, an agency, an administrative agency, has enforcement powers within the agency, and they imposed a civil monetary penalty, a fine, right? It wasn't reimbursement or compensation. It wasn't an award. It's a fine. That's very important. And the SEC fined somebody $300,000. And they do so using an in-house administrative law judge. Talk about biased. And I've had this complaint with New York's administrative law forever. For example, the New York State Department of Health or Division of Human Rights will charge somebody with a violation of their regulations. And as part of that, will want to impose a civil monetary penalty, a fine, right? It is absolutely a fine. And the SEC did so here. But then you go before an in-house administrative law judge who gets paid by the agency. And by the way, indirectly or directly, with fine money. So they're ruling on fines, right, that their own employer said and says, should our employer be allowed to fine you? And the administrative law judge, right? But there's one more point, and I haven't gotten through this part of the decision, but the burden of proof in administrative hearings is so low, right? And I want to explain this. It's so low. So in constitutional claims, we see strict scrutiny cases, very difficult standard. In criminal, you see beyond a reasonable doubt. In a civil suit in court in front of a jury or judge, you have something called preponderance of the evidence, which means if you weighed the evidence, more of the evidence weighed in favor of one side or the other, right? And whoever it weighs in favor of wins. But in an administrative hearing, it is a total BS standard, and it's just whether there's enough evidence, right? The standard is called substantial evidence, but there could be 99% of the evidence in your favor. 1% weighs against you. One thing one witness said, right, which weighed against you, and they can win. They can win on 1%, on just enough evidence. Substantial evidence is enough. It's not more than 51%. So that makes it very difficult to win at administrative hearings. What the Supreme Court did with the SEC is landmark. And by the way, it was the right decision. I know there is one political party screaming against it, but as somebody who does a ton of administrative law, 2 or 3 cases a month in court and hearings, I'm telling you, this is the right decision. It's not a political decision. It has nothing to do with your Democrat, Republican. The U.S. Supreme Court said that the 7th Amendment to the federal Constitution gives every citizen a right to a jury trial before they're convicted of a crime. And the U.S. Supreme Court then says, and also a jury trial before you're fined, sentenced, etc. You have right to trials. And here they said the common law fraud that the SEC was charging somebody with is tantamount to a common law fraud lawsuit in a civil court. And since they are trying to get fines, not compensation, not like I was injured by you that a normal person could get, since you get fines, you have to, the accused has a right to a jury trial. So in short, when an administrative agency is seeking to impose a fine for a violation of an administrative agency's rules or regulations, the accused has a right to a jury trial in court, which gives a higher burden of proof to the prosecuting attorney or agency, and gives you a jury or a fair judge who doesn't work for the agency.
Well, also, you're talking about an Article 3 judge.
Yes,
right?
yes.
It's not an administrative law judge. And
Who may or may not be a lawyer.
Article 1 judges, who are those administrative law judges, and Article 3 judge is one that has life tenure, is appointed by Congress, and really can't be played with by their bosses. There's really no way for the SEC to control them. So that's big.
It's a big deal. So this is huge. We are, I will tell the viewers and we'll move on, but we are preparing. I have 2 cases now, one in Division of Human Rights, one in front of Department of Health. We are reviewing actively whether we're going to make those motions now. This is going to be landmark in New York State, and will start to filter over in other states, as it should with the U.S. Supreme Court decision. But we're saying, listen, you're trying to seek monetary penalties. Supreme Court said you can't without getting to trial.
So what do you think about OSHA? And OSHA has its
100%.
judges. Yeah. So, yeah, this is not unlike what happened with bankruptcy. I know when I was in law school back in '85, the Supreme Court came down and said that bankruptcy judges who are not Article 3 judges cannot hear bankruptcy cases. It's got to be under the auspices of an Article 3 judge. And as a result, they had to reform the bankruptcy system, which is now it's fine. They figured it all out, but it sounds like folks are going to have to figure this one out as well.
Oh, and let me tell you, and just I'll end on this, but you're right. OSHA and state OSHAs, that is going to be so big. I think I would say the same thing, because that's all they do is issue not injury awards, they issue fines and penalties, civil monetary penalties. I think this is going to stop that. Again, this has nothing to do with politics. I wish people would stop saying that. It is the right thing.
They can't resist. They just have to.
They can't. And I'm sick of it. But again, as somebody who practices a ton of administrative law, in administrative law, double hearsay is allowed. It's not, you can't weigh it, but even hearsay, right? So somebody's like, well, I talked to this person and they said this.
Mm-hmm.
It would never be admissible in any court, except in administrative hearing. The investigator appears, repeats his investigation, which is double hearsay. It's talking about 2 out-of-court statements. And this person told me this, and here's what my investigation revealed, and here's the facts. Like, wait a minute, we can't cross-examine the person you talked to, and they never put him on. It is a total farce, and the Supreme Court got it right, and this is going to affect OSHA. This is going to affect a ton of issues that affect the fire and EMS services.
Cool.
Okay, now let's get into this case. Sorry about that long deviation, but it's so important. And I'm not even going to talk about the overruling of the Chevron case.
I thought that's where you were going to go, but that's
and that case is important, right? And look, we could do that very quickly. That case basically said we don't have to defer to an agency's determination if there's a vague statute. That's a judicial function, and the judiciary determines what a statute means, not the agency. That is mind-blowing, since the agency gets to create regulations. I don't know that I firmly agree with that, but I don't think it's a politically derived decision. I think that's insane.
No, my understanding is when an agency has special expertise, such as the FAA, that they will defer to them for things that are within their scope of responsibility, scope of expertise. But when it's not within their scope of expertise, such as interpreting a statute, then the courts should be the ones not to give deference to the agency, but to interpret it, in the context of it being a statute. And I think that's important. Hopefully now we're not going to have courts changing the flight patterns out of JFK, right. Or any of the major airports. Hopefully we're not going to see that. But where the agency is going beyond its special expertise, and every agency has that expertise. OSHA has expertise, FAA, FCC. Right. But where they're going beyond that they're really exceeding their authority.
Yeah, and it's important because there's a rulemaking process, which is a comment period, a notice period. I was just quoted in which was great. The Department of Transportation gave me personal credit for making a big, I'm going to throw this out because go me for a second because no one else will care ever. But as we know, as a result of the East Palestine derailment, the DOT came out with rules on notification to first responders, and they wanted to notify first responders who were in a 10-mile radius by an app, which was ineffective in my ask rails ineffective. But in any event, they wanted to notify any first responder who was in 10 miles of the train derailment. I'm like, this is a horrible policy. One, there may be no cell service. Two, you go to a city and there's a million departments, like Long Island. So I said notification should be made to 911, who has expertise in dispatching, and they agreed. They said, oh, the Pinsky Law Group said this, and we agree. So I was really excited that now all notifications of hazardous material train derailments will go to 911 as opposed to any first responder with an app. So, okay. But Chevron is important because otherwise there's a rulemaking procedure, and they could instead not go through rulemaking and just issue opinions, right? Oh, our opinion as to the interpretation of the statute is this, and they could then avoid going through rulemaking. And the Supreme Court says you can't do that. And that it's 100% right, 100% right, not political in any way. Okay, on to yours. Right. So let's start with we've got a Fair Labor Standards Act overtime suit out of West Virginia. It's long, people should read it, but here's a summary of it. And this is another good example of bad policy drafting, or no policy drafting in this case, for HR manuals and things like that. So start with my point. HR manuals need to say how you're being paid, what your work week is. I'm sure every state law has this, but what your work week is, when it starts, when it ends, what is overtime, which is normally, 1.5 the regular rate for that pay period. You got to define the pay period. And every employee, at least in New York law and certainly under federal law, has a right to what is your hourly rate. And you're supposed to give a written notice, both upon hiring and then annually thereafter if the rate changes. But it's got to say what their hourly rate is, especially on every time or every pay slip. So in this case, we have 56 firefighters with the Morgantown Fire Department, West Virginia, if you're a fan of the football team. I am not. But they've claimed that the city hasn't been paying them properly. And what they do, I'm going to read one unbelievable example as you make note of. But basically, the city has no idea how they pay anybody, how they calculate the regular rate, what the payroll week is, what the hours are, how they calculate it. And there was testimony in another semi-related lawsuit about how they do it. I had to read this 3 times and I still didn't understand what it was. But basically,
what it comes down to the fact that on paper, they're saying they're doing it one way, and in reality, they're doing it an entirely different way.
Right.
So how are you paying these people?
And as a result, the hourly rate is actually, they're making it lower than it should be because they're dividing the number by hours.
They're going to pay their employees overtime after 40 hours in a work week. So that means every 7 days, they're going to look at how many hours they worked and pay them overtime. There's nothing about firefighters.
Right. Which is shocking, by the way.
Well, most firefighters are working 53, 56 and more hours per 7-day period. And also it fluctuates. It goes up, it goes down. And the city apparently did not have, at least according to the complaint, they didn't have a written payroll policy that addressed firefighters. And then apparently in this case, and I'll let you explain it, but the city manager, assistant city manager under oath, I'm not sure if it was a deposition or in court, but tried to explain how. And
it's not even understandable. It's like we take the first 2,080 hours and that's the 40 or that base pay. And then there's another 700 hours we do something else with, and we calculate vacation and overtime. It's insane. I can't even go through it. But one of the things they said is, look, you're doing something on a 3,208 hour period. And they're like, there's no firefighters who are scheduled to work that. So all they're doing is using more hours to reduce the hourly pay, which again, the overtime rate is 1.5 times the regular rate of pay. You got to know the regular rate of pay, and they have no clue. So here's the point, people. I am hoping when you end this, you will go back to your HR manual and whatever else you have governing your employees. There has to be a pay week defined, Look, if you're paying on 40 hours, kudos to you,
Yeah, you can't do
firefighters.
that. Yeah, that is absolutely insane for most fire departments.
Why would a municipality not? But it sounds like they had no idea how to hire anybody. This is a lawyer's fiasco, in my
Brad,
opinion.
you were on vacation last week. We covered it wasn't the same facts, but it was close enough where we see some parallels between this and the case we covered last week, which was in Clarksburg, West Virginia. And it's the same law firm. In fact, the same attorney is handling both cases. And in that case, there was they had just sort of made up a number. It was 3,400 and something hours, and they were taking their annual salary and dividing by that to come up with their hourly rate. And you've got to have a good faith basis to determine somebody's hourly rate. You can't just, kind of make things up off the top of your head. You got to have some sort of methodology. And I think that's it. Now, if your people are scheduled to work, and if you do the math, if you work 56 hours a week, it comes out to 2912. I think 56 times 52 comes out to 2912. If you do 53 on average, it comes out to 2756. So there's certain numbers, and the 2080 is 40 hours times 52. So there's certain numbers that keep coming up, but you have a good faith basis for using that to calculate the regular rate. Where do they come up in this case? 3208. Right. And maybe they do have a way, but they're quoting this assistant city manager, and it doesn't seem like she has a clue about how that number is calculated.
And I want to see the pay stubs. The pay stub have to have hourly rate on it. It's it's supposed to have it. I don't know what they have here.
They can have it. Here's the thing. You can pay an employee a salary. There's no problem paying somebody a salary, but you've got to have a methodology for reducing that down to a regular rate for purposes of overtime.
Yep.
And so, again, people get confused when you say salary. They assume that you're talking about an exempt executive.
No.
That's not accurate.
Right.
Okay? An hourly employee can be paid a salary, but then you've got to calculate what their hourly rate is and then calculate their regular rate from that.
And then it gets even more, I'm going to make a conclusion in a moment, but it gets even more complicated because if you have guaranteed stipends, if you had other, if you're a paramedic, you get this money. Well, that's got to be divided by 365 and factored into the overtime rate. I mean, there's more than just this. My point to everybody who's watching this is this. If you don't have dead clear understanding of how you're getting paid, what your payroll week is, how much you get paid per hour, etc., call Curt. Hopefully I'm pointing in the right direction, but seriously, call Curt, because no attorney should just dabble and say, oh, we'll just figure it out. There are so many, right? Well, we assume you're going to work 48 hours on week. We're going to have right? On average, some weeks more, some weeks less. And what if we go to 58, 150, another, right? There's so many issues that people screw up, as we've seen in cases, including the next case coming up, where lawyers who don't know how to do this, or HR people who don't know how to do this, you're messing it up. I'm telling you, this is my paid advertisement here. No, but call Curt, seriously, because this is so confusing. You do not want to guess what seems like a good idea.
And we've got some classes coming up. Of course, I can't give legal advice outside of Rhode Island and Maine. So, but I can work with out-of-state attorneys, and I do regularly work with out-of-state attorneys. So what you should do is have your attorneys reach out to me, as opposed, because I'm not, if you call me from out of state, I'm going to probably say, I can't answer that question, but have your attorney contact me and we'll set you up.
Yeah. Okay. So now, similar but different.
Yeah.
Maybe they have the same EMT or same attorneys.
No, she's handling the cases in West. I should reach out to her, but maybe I will this week. But
it'd be interesting. So now let's just hop over a little bit to Virginia, right? Mm-hmm. Not West Virginia, where the last one was, but Virginia, where we have EMTs. And look, I'm sure we're both thinking the same thing. If the complaint is true, yeah, they're getting money. Oh, man, so we have Virginia EMTs who do not perform structural firefighting. We'll have you talk about the tests in a minute, and they're getting paid like they had structural firefighting or interior firefighting as part of their job description, and they don't. So to be clear, what we're talking about are not EMTs. We're talking about EMTs who do not do any firefighting activities, right? And we should go through the test in a second. But here's what happened: the city's treating them like firefighters, paying them like firefighters, but they're not. firefighters. So that's problem number one. Problem number two is insane. But so one, they're not getting paid overtime, and their rate's probably wrong too. But the next part about that is crazy as well, right? So these people need to be paid at 40 hours a week, and everything after that in a work week, right? You're going to see why I'm stressing that. In a work week, you have to be paid over 40 hours at time and a half, the regular work week rate. And the next problem is they would pay them like 2 checks monthly, and they would say the first week is at straight time, and the next week we'll figure out overtime if it's over for that. I mean, I don't totally understand it, but here's what I'm going to read it from you. So defendant developed a payment scheme wherein the plaintiffs and other people would only receive straight time on their first check of the month, regardless of how many hours they worked. And then on the second check of the month, they would receive straight time payments for the hours worked during the second half of the month, and then the overtime premium for those hours worked in excess of the 212 hours in that month. And I don't know whether it works out.
That's more in the nature of how firefighters are paid, and that's the fundamental issue. They were paying them like firefighters. Everyone else, other than police officers, everyone else has to be paid overtime on a week-by-week basis. Firefighters, you can go out to as long as 28 days. Some departments will go 14 days, some will go 21, 24, 18. There's all different ways of doing it, but you can go out to 28 days. You can't do that if you don't qualify as an employee in fire protection activities. And
so let's talk about that.
And there's a very specific definition. We call it the 203Y definition, but it's 29 USC section 203Y defines it. And this became so contentious that Congress actually had to go back and redefine it, because they used the term in the FLSA, employee in fire protection activities. They didn't define it. And there was all sorts of cases about our dispatchers, our medics. So finally, Congress actually, and think about as contentious as Congress is sometimes, they realized, oh, we got to fix this. Okay. Right. So they went back. But number one, you got to be trained. You've got to be trained as a firefighter. Well, if you're not allowed to stretch an attack line in a building, there's a question. You can maybe get 2 hours worth of training on a fire extinguisher, but if your boss makes you stay outside, there's a question about whether or not you actually have the training. And then you have to be, and I want to get it right here, you have to have the legal authority and responsibility to engage in structural firefighting or firefighting. Okay. You have to work for municipalities. This is not something that nonprofits, volunteer fire companies can take advantage of. And then you have to actually be engaged in responding. You can't be, at headquarters or at the training division or whatever. You have to be actually engaged in responding to emergencies. So, they're probably not trained. Or fully trained or as trained as firefighters were allowed to go in a building. And then there's a question, do they actually, when they go to a fire, do they, stay in the cold zone, or, they handling EMS, or are they actually engaged in firefighting? And if they're not actually engaged in firefighting, they didn't fail on the training part, they're going to fail on that actually engaged part. So,
these suits are becoming more common. We just filed one the other week. We'll make it, it's public, but we'll make it more public soon. But do not mess with the FLSA. Do not mess with minimum wage. Do not mess with state laws on payment. Do not mess with anybody's salary. You are going to lose at least 2 times the amount of that, right? Plus attorney's fees.
We go back to the West Virginia case. That actually, under state law in West Virginia, it's treble damages. Wow. Okay. Wow. Federal law is double damages. But when you make a mistake in West Virginia, it's triple damages, plus attorney's fees, plus costs, plus interest, and everything else. So big consequences.
Yeah. And they can go back, right? It generally starts with 2 years.
Yeah, generally 2 years. But if it's willful, then it's 3 years. And, proving willful, a lot of times judges don't like to find municipalities willful, but where it's pretty obvious, they sometimes don't really have a choice.
Right.
So.
And I think in the West Virginia, it looks so incompetent, if true. It looks so incompetent, if true. I don't think anyone would say it's willful, right? I suppose they're going to try to argue, say, how could anyone be that incompetent? It must have been intentional. I don't know.
It can cut both ways, I guess.
Yeah. Okay, so enough of that. The next one, which we're going to talk about in Chicago, we have a firefighter's discrimination claims, which I really want to talk about, were dismissed. And this is so important. Now, it talks about summary judgment. I don't know if it's summary judgment or it was a pre-answer motion to dismiss, because reading it, it almost looks, and some courts use the same terminology, but it almost looks like a pre-answer motion to dismiss. The reason I'm saying that is because what the court does is it focuses on what was pled and talks about the insufficiency of the pleadings, not the insufficient and the insufficiency of the allegations. I'm going to explain why. But everyone should pay attention who employs people here, because all the time, and I see this all the time, for example, and then I'll get to the facts of this. About 4 months ago, I had a client who said, well, they fired somebody and she said, you fired me for my disability. And her lawyer sends a proposed complaint, a proposed lawsuit saying, we're going to file this. And I turned around and said, what's your disability? Oh, we don't have to tell you, he says. I said, well, it's not in the complaint. You don't tell me what your disability is or how, right, our client's decision affected you. I said, you're going to lose. And he said, show me a case. Now, here would be a case because this individual claims that they were retaliated against. I'm going to focus on two main things. One, because the department, they should have raised a Monell case here, but the department has a policy or a practice of discriminating against people generally in terms of bathrooms and other things like that, right? There aren't enough women's bathrooms at a station. And so they said that's a general practice discrimination. The court says, maybe not, but you never stated in your lawsuit how you are impacted by that, and they know you're at a different station. So these practices, which may or may not be discriminatory against women, they said, but that's somewhere else, and you're not personally affected. So you can't sue. You lack basically standing to sue. There's no jurisdiction by the court. So that was a big deal because all the time you get these vague statements, oh, you're doing this. Yeah, but how did it affect you personally? It doesn't matter what they're doing to someone else, or not doing. Someone else didn't sue. You sued. How did it affect you? So that's Brad, one big, huge part.
Just so you know, I'm not sure I put it in there. She filed pro se. I don't know if did I
put, okay.
This is a pro se suit. So
she got no lawyer, which tells you a lot, unfortunately, about cases that lawyers don't want to take. But the next part that she then claims is that she says, well, I have faced some things based on something I'm not going to tell you about, right? She says I face race discrimination, and possibly national origin discrimination, but she fails to state, which I love this part of the case, what her race is or her national origin is. So you can't be vague. This is the point for plaintiffs lawyers out there. You can't be vague in just your claims. You can't say, well, you're attacking me because of my disability, my race, religion, but I'm not going to tell you what it is. Because you have to then say how it impacts you, how they're affecting you. Because on the other side, the employer has the right to say, wait a minute, we can't accommodate that disability, right? Maybe you're a type 1 diabetic or an active seizure person, and they won't allow you to be an interior firefighter. Well, if you don't say what you have, how is anyone going to respond to we can or we can't accommodate it? How can
you be accused of discriminating against somebody if they won't tell you what their disability is? How exactly did you discriminate?
And funny, I have that case going on, not a case, I have the threat of the case going on today where they said, you discriminated against me based on a religion. And I say to the client, does anyone know what their religion is? They're like, no, he never told us. I said, is it on an application? No. I said, does the person have any like hat or hair of significance that might, suggest they're Jewish or something else? And they're like, no. I'm like, so how can you discriminate if you don't know? Or if you can't even perceive, right? Could be perceived race or disability. But in any event, this, and I apologize to the person, I'm not trying to upset you, but all the time I get these BS kind of complaints, which say, well, you're discriminating against me, but I'm not going to tell you how, but I'm suing you.
Right.
Come on, right? And so that was a big deal. But she also, again, fails to allege anything that happened to her directly. Now, the court does, however, probably be nice, say, on the other hand, the retaliation claim survives. Now, if you haven't been watching us for a year or two, Curt and I always say one thing: where there's a discrimination or harassment claim, there's always coming a retaliation claim. They complain, right? Or they state they complained about it. They state they told somebody about it. And then all of a sudden they state things are going worse. And the court allows the retaliation claim to survive because there she's a little more specific, saying what things happened to her. Not everything, but some things happened to her. And she can state that she herself faced. That's a quote from the court, but she can talk about that.
When it comes to retaliation, I like to say that it's so easy a caveman attorney could win it, you know, or so easy a first-year law student can win a retaliation case, because in this case, she loses her race discrimination, and which I believe is a reverse discrimination. She didn't get into it, but I believe it's a reverse discrimination. She lost her gender discrimination and all the other discrimination claims, but she could prevail on a retaliation claim. Okay, there's no problem. It's a separate issue. She doesn't have to prove that she was right when it came to those discrimination claims. All she has to do is show, I filed a claim, and after I filed the claim, these adverse actions happened to me.
Right.
And that's it. It's so easy a caveman attorney could win it.
Now, what I didn't see in here, correct me if I missed it, but what normally happens with pro se clients without attorneys, when they file a deficient pleading that lacks sufficient facts, normally the judges will say, I shouldn't say normally, but in many cases, the judges will say, listen, we're dismissing it. You have leave to replead. You can amend it and we'll accept that. And then we'll reconsider any motions. And they basically go through, like they did here, telling you, here's your problems you have, what you didn't say. I didn't see in that, and unless you see a leave to replead, I think it was a straight out dismissal.
Yeah, I mean, this case has been circling since 2021. I'm looking at the date here. It was filed in 2021. So I'm assuming that's probably why it wasn't a 12B6 motion and why it was a summary judgment. So it's been kicking around, and I'm seeing the operative complaint is a SAC, second amended complaint.
Okay.
So she's had one opportunity. The court can give her another opportunity, and that may, we'd have to get into the weeds of the decision. It's a pretty lengthy decision to see if the judge is going to allow her the opportunity to amend.
But my takeaway to everybody is this: when you're threatened with something, they have to say, how you're discriminating specifically against me, not generally. Now, how you discriminate against others generally will be used to prove that they're a discriminatory department. For example, we have no women of any rank, right? And you failed to promote me. Well, the fact that you failed to promote other people is not a problem. The fact that you failed to promote me is, but I'm going to use the fact that there's no women of any rank, right, against you, but that doesn't win it. That just helps prove my claim of discrimination against me. But, if you're one of those people who are about to be fired, you're one of those problem type employees, and you're going to, instead of look inward, you're going to blame everybody else for what's happening to you, and they're not doing anything to you. You better put pen to paper and be able to prove what they're doing to you. Yeah. So, okay. Let's go to Indiana.
Yeah.
I need an aspirin and some vodka, I think. You properly state what we're about to talk about is very specific to Indiana, in that I have not seen another state use two rules like we're about to discuss here. So the normal rule for everybody to play catch up. Right. I always think this is such a good, I tell people, watch our show because you learn so much about the law, right? And your professional development. You should get credit for watching, honestly. You're going to learn so much. But there's something called the Firefighters rule. Now, the Firefighters rule normally is a judge-created rule. Normally is a judge-created rule, which means there's no law on it, just judges came up with it. And it generally says that firefighting is a dangerous activity. And when you go to someone's house or property that they invited you in by use of a fire alarm or phone call to 911, whatever, They've effectively invited you in, but when you get injured on the job, you're barred. You can't sue. It doesn't matter how you get injured. Now, that's unfair, but that's the normal firefighters rule.
That's the traditional rule. And it has, and you want to get complicated, it has a couple of bases. There's a property law aspect. So you get into licensees and invitees and all that. That's one way of looking at it. The other is workers' comp, that you've got workers' comp or you got a pension or whatever it may be. And we don't want to burden the taxpayers and all that. Another policy issue, we don't want them not to call 911 because they're afraid that they may be liable if somebody gets hurt. So all of those different things combined to lead to the traditional firefighters rule, you can't sue.
Right. And by the way,
and then we have the exceptions.
Right. And the who you can't sue, right, is you can't sue the property owner or whoever.
Some states you can't sue anybody.
Can't sue anybody.
Some states you can't sue it. Some states you can't sue the property owner, but you can sue third parties. So let's say there's a contractor there. It's not the property owner, the contractor there, and you trip over something the contractor left, you could sue the contractor. Okay.
Right.
Some places you can't sue the person whose negligence caused the fire, but if there was other forms of negligence, you could sue whoever was negligent.
And that's where Indiana's coming to start. So that's a great lead in. So based on going back to the facts here are important. Curt and I discussed this on a prior show. But basically there's a fire in a building. The firefighters enter. There's no covering on the staircase. And the firefighter falls, I think, down the stairs or through the wall because there's no protections. Yeah. Clearly, if a normal person walked into that house, unless there was warnings or barricades or if you should have had a staircase or protection and there wasn't, somebody got hurt, you're going to lose the lawsuit, right? You created a dangerous situation. Here, we have that situation. No question, there's a dangerous condition, but the court starts parsing out, and I get it. It's not hard. I get why they do it. And in fact, it makes sense to me, but it's so unique. I've never seen this anywhere. But basically they say, okay, there's the firefighters rule, right? But we have the firefighters rule, but then we also have something called the rescue doctrine. And they start trying to divide this out. Let me talk about concepts in general. So we talk about the firefighters rule, right? And basically, as part of that, in most states, you have the rescue doctrine when you went, right? But the rescue doctrine basically states this. I'll give you an example. If you cause the injury, you have a duty to that person, right? But that rule is normally like, okay, you hit somebody with your car, you have a duty to call 911. In some, it's if you're a parent of a minor, you have a duty.
Actually, I remember the case from law school. It was a pretty good one where someone on a ship tied up to somebody's dock, and the person whose dock it was came out to help. There was in a bad storm, and the person was injured. And there's basically the ruling in the court is that if the person was negligent, they're responsible for the injuries because danger invites rescue. And
that's the rescue doctrine.
Right. That's the rescue doctrine, that when you put yourself in a situation where you need to be rescued and someone foreseeably comes to your rescue and as a result is hurt, you're liable. Your negligence puts you in that situation. You shouldn't have been out in the storm. You shouldn't, you should have been watching the weather. You shouldn't have been out in the storm. You came to this person's dock. That person came to help you, and then they were injured. Your negligence put you, assuming that the person was negligent, your negligence can be the basis for that.
And here the court says for a first responder, it cannot be. If the reason you're injured is directly related to the reason of the emergency, right? So take the simplest one. You get called for a house fire and you get injured by the fire, right? You cannot sue.
Well, you can't sue the person who was negligently responsible for causing the fire.
Right. But let's take a hypothetical. But if somebody was outside and hit you with a car while you're responding to the fire, right? That has nothing to do with anything. You can sue them. So here, there's basically the court says we got some questions of fact, which we're not going to resolve, but they lay out the kind of thought. And they say, well, if failing to have the wall was related to the cause of the fire, then you can't sue.
Right.
But if not having that was related, and I'll give you a direct example of this, but if it had nothing to do with the cause of the fire, then you can sue. The negligence was separate from the cause of the emergency. And here's what I would say.
This fire was a e-battery with a scooter, an electric scooter.
Right.
So.
Now, if the house had been constructed properly, they would argue, then the smoke wouldn't have filled. It would, and this is what they argue, that wouldn't have become a smoke-filled condition, and he would have been able to see, and he would not got injured, so it's directly related, so you can't sue. That's what they would say. I would, and obviously there's a question of fact, right? We don't know, and they're going to leave that up. But look, it's a good holding. It's a good lesson. As you say, this is more for the legal eagles. This is Indiana, very unique. Most states, you're either a firefighter either can sue or not sue. Under the theory, by having an emergency, they invited you in, and you're liable for the property to anybody you invite in. And they even discussed that in this case, but that's the normal exception to the firefighters rule, right? If you invite someone into your house, if they get injured, it doesn't matter whether it's related to the emergency or not, generally. Now, if you get injured by a fire, right, even in New York State, which has a very good exception to the firefighters rule, you're still not going to be covered. But you fall through a floor because I cut a hole in the floor and then there's a fire, okay, you're going to lose a lawsuit. I'm happy in New York State, I have one of the main cases to this where somebody was directing traffic and they get hit by a car. Had nothing to do with the emergency that was down the street while they're directing traffic. They get hit by a car. Even in Indiana, they would win, right, under that set of facts because the actor, it was somebody else who caused the injury, totally unrelated to the emergency. So great case. You don't see the rescue doctrine and firefighters rule tied together in too many cases.
No, and I'm not sure that they necessarily need to be. I think the court kind of did a little bit too much thinking in this one, but it is what it is. In Indiana now, I guess you're going to have to deal with both the firefighters rule and the first responder exception to the rescue doctrine. I think that's probably a better way to characterize it. So
yeah, that would be, but so confusing. So it's that's not normal. If you're outside of Indiana, don't get too worried. But you do need to know whether there's a firefighter prohibition or not.
Sure. And
okay, and now we're going to end up.
Many states have gotten rid of the firefighter rule. It's really I think it's unnecessary. Let the facts speak for themselves. If somebody's negligence led to a firefighter being injured, so be it.
Right. I agree. So, look, I've said it a million times. How many times at least where we are, right? Maybe not in California, but how many times have you walked up a driveway carrying a shit ton of tools, pack on, and you're in, God forbid, the rubber boots, which were worse, right? But leather, whatever, and you fall in the driveway, and I've fallen straight back, right? And you're on SCBA on your back. I'm out for weeks. It hurts. Well, if the ice formed a week ago, then that property owner should be liable. Because that's not the emergency we're responding to, for one, and you should be liable. If I get hit by a car, you should be liable if you hit me with a car. If I'm directing traffic, whatever it is, homeowners have a duty of care to the people they invite in. Whether you intended to invite them in or not, you did. You put up an alarm, or you called 911, or you left food on the stove, which created smoke, which caused someone else to call 911. Whatever you did, you placed a series of events to bring someone in, and the short answer is don't leave your home dangerous. No different than the mailman.
And there's another aspect to this that people don't consider, but it's the municipality's right of subrogation. Because if you get hurt and you collect $500,000 and the municipality paid your medical bills and they paid you while you were off injured, you're entitled to some of that compensation as well. So they are entitled to share in whatever recovery you get from the negligent party. So there's otherwise it falls on the taxpayers, and it's not intended to be a windfall for the person who's injured. It's compensation for the injuries.
Right. We should do a whole, any state that doesn't have, has an advanced pass the firefighters rule, we should send them this. Okay. Last one. I'm going to make this easy, but it's
because this is a tough case. It's a fascinating case.
It is. And unfortunately, the degree of negligence that's surmised here, right, is significant. But we're now in the Sixth Circuit, which is federal court. And we're talking about a lawsuit brought by insurance companies against the federal government because the insurance companies paid claims for a 2016 fire called the Great Smoky Mountain Fire, which burned, talk about the scale. It's important to talk about how big this got because that's the point of the negligence. There are 16,000 acres, right, burned or damaged 2,500 structures, destroyed the city of Gatlinburg, and killed 14 people. This got massive, but it starts with a series of allegedly bad activities where somebody, and they talk about him, but he's from the National Park Service, I believe, and it's his job to look for fires, evaluate fires, estimate a fire spread, estimate resources needed, how big or bad is it going to get, can it be fought, all of that, right? And we should talk about, before we leave here, discretionary policies, discretionary procedures, mandatory policies, because discretion is going to matter in this case. Mm-hmm. So this individual sees there might be a fire, has a very hard trek to get to the fire, looks at the fire, makes an evaluation that it's not going to be a big deal. It can wait. We've got a lot of people on leaves who we've sent home, and we're not going to call them in. We don't need to. And effectively, this is why I can make the facts pretty easy. The fire keeps growing and growing and growing. There's an allegedly bad set of facts that keep happening. Well, we didn't bring in people, it's too late, or we didn't estimate that the wind might pick up and spread as much as it did. But the allegation here is they deviated from policy, right, which had to happen, and the guy's acting as incident commander and something else. He's got too many roles. And again, the allegation is this didn't have to become as big as it did, but it did get that big, and it should have. And had he done things properly, we would have had all this destruction. You kept treating it like a non-growing small fire, right, to say that way. So the court goes through this long litany of everything I just said, allegedly bad decisions, which underestimated this. And so ultimately the plaintiffs, the people suing, sue the government for negligence under the Federal Tort Claims Act, which is where you're allowed to sue the government under certain circumstances, right? The government has immunity, but says you're allowed to sue us under certain conditions, certain issues, et cetera. So they sue, and they said you were negligent. The government is negligent in failing to follow mandated fire management protocols. Mandated, not discretionary, the allegation is, and for failing to issue mandatory warnings to the public about the fire as required by the policies set forth in 5 agency documents. And they basically said you failed to follow the incident command structure. Now, that's also federal law NIMS, right? You failed to follow mandatory fire monitoring protocols, and you failed to follow the wildfire decision support system required in developing and authorizing a fire management response. There's a very allegedly, a set of rules on what you must do. And so the Sixth Circuit federal court agrees with the trial court that the dismissal of the insurance negligence claims, right? They were negligent. They said, listen, we agree what happened was not protocol, policy, mandatory. It was discretionary. And because you exercise discretion to how to follow things, and the protocol allowed for discretion, presumably, we're going to dismiss the claims. And we've said that a million times on here, right? If something is properly discretionary, you can't say everything's discretionary, but if something's properly discretionary and they exercise discretion, which the protocol allowed, you're not going to be liable for that. But here, they did say the insurance companies can pursue the duty to warn claims. And there they go through, say, well, the duty to warn claims, you had a duty, right? And we're going to allow that to go forward. But if it's discretionary, you're not going to be liable. And usually, not always, that wins the day, right? I suppose they could say your discretion was so bad, nobody would have ever made that decision. But here the court goes through and really focuses, this was his thought. This is what they were seeing. And there's some understanding of why could go this way, could go that way, could go left, could go right. And he kept making decisions, but he did make other decisions like call in planes, call in helicopters, send people home.
You know, one of the things when I look at a case like this, one of the things I look at this and I say, you know, an attorney could look at this and say, oh, we've got to fix our policies, you know, so that we can't be held liable. To me, liability, that people died in this fire, 2,500 structures were damaged, thousands of acres. Okay. it's not about liability at this point. You want to make sure that your policies are geared to prevent this from happening. Once it happens, once you hit the iceberg, once the Titanic hits the iceberg, you're going to be sued. You know, and they are going to find a way, if possible, to hold you liable. The purpose of your policies is not to give you an escape clause so that you can do something like this and not be held accountable for it.
Right.
Only a lawyer thinks like that. What we've got to be focused on in our policies is how do we make sure that a disaster like this doesn't happen again?
Right. Right. And you know, look, and you said it, policies are designed to give you no discretion so that you achieve the outcome intended.
Depending on the policy. Either we provide you with the discretion, or there's certain things like our SCBA policy. You don't have discretion. You will, if you're going into an IDLH,
We'll wear SCBA.
You're driving in an apparatus, you will wear your seatbelts. Okay. So some policies we have no discretion, others there is discretion. But again, at the end of the day, it's not like we're going to come up with a magic policy that would allow the owners of the Titanic to run their ship into an iceberg, kill 1,500 people.
Say it was discretionary.
Go, you know, it's okay. You know, we're not liable.
We could have turned the ship, but we didn't want to.
Yeah, you know, that's not what it's about. The purpose of the policy is to avoid the damn iceberg. And you look at what happened and what are we going to do to fix our policies to make sure this doesn't happen again?
Exactly it. And when you don't want an outcome, the policy that says you shall or shall not is exactly what you say. Okay, well, that was a lot, and that was an hour, but that was good stuff this week. This is such a good primer to on so many issues. This was a good week. I hope everyone got a good education out of this, and All
right, that'll do it for another week. I just caught a run. I'm going to have to head out. So.